Thanks for watching. This short video covers the authorities that will be responsible for enforcement and the penalties for breaches. We can't cover all of the circumstances that can lead to a penalty, so I've chosen a few examples that seem most relevant. Every local housing authority will have a duty to enforce landlord legislation in their area. There will also be a lead enforcement authority. That will be a combined authority, the Greater London Authority, or a local housing authority. For example, Bristol City Council was the lead enforcement authority under the Tenant Fees Act. Remember too that membership of the Ombudsman or registration scheme is mandatory, and that the scheme can award up to £25,000 to complainants, and that those awards are enforceable as court orders. Plus, failure to pay means ejection from the scheme, and then you will not be permitted to rent out a residential property. So, scenarios under which you may be fined: offering a fixed period tenancy, excluding the small number exemptions, or trying to end a tenancy with a notice to quit. Neither of those will have any effect. The tenancy will be an assured tenancy, and the notice to quit has no legal effect on the tenancy. If the local authority is satisfied beyond a reasonable doubt that this has occurred, they may issue a fine of up to £5,000. Misuse of grounds 1 or 1A, which is when the landlord wants to move in or sell the property may not be relet or remarketed within 3 months of regaining possession on those grounds. If the local authority is satisfied beyond reasonable doubt that this has happened, they may issue a fine of up to £30,000 as an alternative to a criminal prosecution. Failure to provide a written statement of terms is punishable by a fine of up to £5,000 where the local authority is satisfied beyond reasonable doubt. If the offending behaviour continues for more than 28 days, additional fines may be applied. If a landlord is not a member of the redress scheme, they may be fined up to £5,000. If they do not then join the scheme within 28 days, another fine may be issued. If a letting agent advertises a property whose landlord is not a member of a redress scheme, they too may be fined up to £5,000. If a person has received a fine for failing to be a member of the redress scheme, and they are again found not to be a member within 5 years of the fine, they may be fined up to £30,000. If a property is let or advertised to let without both the landlord and the property being correctly registered in the database, then a fine of up to £5,000 may be issued. If another offence is committed within 5 years, then a fine of up to £30,000 may be issued. The Protection from Eviction Act 1977 has also been amended so that the local housing authority may issue a fine of up to £30,000 if they are reasonably satisfied that an offence under Section 1 has been committed. That means, essentially, doing anything to interfere with the peace and comfort of the occupiers or their household, withdrawing or withholding services, or preventing the occupiers from accessing the property or any part of it. These fines are able to be increased to keep up with inflation so that they remain a strong deterrent over time. And next video, timings and transitional arrangements.